CETA has been described as the most ambitious and progressive trade deal ever signed by the EU. The 1,500-page agreement entered into force in September 2017 after 7 years of negotiation, an intense protest campaign and a threat of veto by the Belgian region of Wallonia. A year and a half after entering into force, what has CETA achieved and what concerns still remain? CETA has removed virtually all customs duties on goods between Canada and the EU, totaling around 590 million euros per year. It has improved access for EU companies on Canada's services and public procurement markets. It facilitated the movement of people and formalized the recognition of professional qualifications. And 143 of the EU's geographical indications of high-quality food are now protected in Canada, such as Greek Kalamata olives, German Schwarzwälder ham and Dutch Gouda cheese. What has been the result? It is still early days, but the impact on trade is already visible. In the first 9 months of application, the EU registered a 10.3% increase in goods and services exports to Canada. In Belgium, for example, chocolate makers exported 34% more to Canada after benefiting from the elimination of 10% tariff. And there's still no sign of chlorinated chicken or hormone-treated beef. But what about other concerns about CETA? One of the most controversial issues was the system to settle disputes between investors and the host state. CETA was the first trade agreement in which the EU negotiated these opaque quotas on behalf of the member states. Responding to concerns raised by civil society organizations and the European Parliament's request, the EU reformed the existing investor-state dispute settlement to replace the international arbitration with a new investment court system in CETA. Under the new system, investors have no say in choosing the members of the dispute settlement. Instead, the court will be made of a tribunal and appellate body selected on a rotating basis from a group of judges. Although some issues remain to be concluded, such as the court members' code of conduct, the new design helped to convince some of the past critics. In addition, the EU Court of Justice blessed the new system and concluded that it did not jeopardize the autonomy of EU law. CETA's ambition derived from its goal not only to scrap duties but to progress on non-tariff barriers. NGOs and unions fear that the EU was risking to downgrading stricter EU regulations or to weaken labour rights. However, no article in CETA sustained a blind race to the abyss. The deal integrates the EU's and Canada's commitments to imply international rules on workers' rights, environmental protection and climate action. These obligations are binding and includes the ratification and implementation of the International Labour Organization conventions. But unions call for a step further to include binding penalties for violations against workers' rights to ensure that labour standards are as enforceable as investment rules. As the EU and Canada are like-minded partners in protecting the environment and fighting against climate change, CETA contains a trade and environment chapter that includes commitments in areas such as on the sustainable management of forests, fisheries and aquaculture. It also binds both partners to effectively implement all ratified multilateral environmental agreements, now including the Paris Climate Accord. The deal did not open the gate to Canadian oil sands exports to the EU, and fuel produced from oil sands and oil shale remains subject to strict EU law. CETA will require close monitoring and support to those who may not benefit from it. But compared with past trade deals, the agreement improved the inclusiveness to ensure that civil society groups can control that the commitments made are implemented, including an open review clause to enforce all its clauses. Transparency is an ally for CETA to remain as a model for future trade deals in times of rising protectionism fueled by disinformation and false claims.